while we are speaking about the difference between sale and agreement to sell, I think this slide will give you some kind of an idea of the difference between these two legal contractual terms. Now, what is also important for us to understand is that once sale occurs, the parties get right against the whole world. That is what we call as rights against world or jus in rem. Whereas when it is agreement to sell, it is jus in personam, which is that yes, it has legal validity, but just between the parties. Jus in personam means between the parties, and jus in rem means against the world. However, what is important for us to understand is that the remedies, though they are different, the legal enforceability of an agreement to sell is very much established through several case laws, and this has now become a very important element of holding people accountable for fulfilling their contractual obligation. If they do not complete their contractual obligation, they shall be responsible or liable to compensate and pay damages as well. Critically, what you can also notice is the kind of risk that passes with sale as against agreement to sell. Now, if you notice that if goods are lost by fire in a sale or after sale, if the goods are lost by fire, then because the sale has occurred and the title has transferred, the buyer is liable to bear the loss of those things that occur due to the fire. So once the title passes in sale, it is the buyer's risk. Whereas in agreement to sell, because title does not pass, you will notice it is the seller who will continue to be responsible as an owner, and anything that happens to the goods due to fire or any other accident or incident, then the seller continues to be responsible for the same. So this, I think, is a critical juncture for us to understand, because when we talk about government contract or tendering and public procurement, you will notice that we have several kinds of forms or several stages in which contract is made. For example, I can just put at this point of time a very interesting proposition for you, in which we discuss the fact that, look, there is the selection of lowest bidder number one. L1 declaration becomes the critical stage of contractual making in government tendering contracts. Once L1 is declared, then the second stage is issuing of the letter of intent. The third stage is a stage where either the purchase order or the work order is issued, or you will notice that there is an element of an agreement that comes into place where both the parties actually sign that kind of an agreement. Now, these may be the stages of a contract. However, the parties are confirmed with their contractual obligation as soon as the L1 declaration is made. Right? Rest are processes and procedures. And once L1 declaration is made, you will notice that it becomes a stage where the parties are locked in for the contract. They cannot exit the contract unless they owe certain obligation or liability towards each other. Right? Now, if we understand what sale is, you will notice, friends, a sale is an intention of the party to undertake a transfer of property. Now, transfer of property, friends, is a critical element of the Sale of Goods Act as well as the Transfer of Property Act 1882. The intention to transfer the property is critical to sale. Intention to transfer property. Now, property means title. Property means possession. Property means that the seller has said, now from on, the goods belong to the buyer. And whether the price is paid or not at that point of time or simultaneously doesn't matter, because we have understood in the past what a credit sale is. Now, friends, in credit sale, you will notice that the intention to transfer property exists as soon as the sale takes place. However, the price in the goods may be on credit, or it could be on equated monthly installments, or what we call as EMI. Right? So the price is not the determination of the point of sale. What is determined is the intention of parties, and that becomes very important, and that is what the Sale of Goods Act actually states in section 4 of the Sale of Goods Act of 1930. Now, going a little bit further, friends, I think it's critical at this point of time for us to understand certain definitions which are very important, and these have important bearings on the kind of contract or the nature of contract that we make in government and private sector. Now, the interesting aspect that we can look is sale of goods, right? What does goods mean? Because this law covers only goods and not other kinds of contracts. So how do we understand the term goods? I think that is very important, and that's why section 2(7) of the Sale of Goods Act of 1930 defines goods. It says, goods means every kind of mobile property other than actionable claims. So mobile property is goods. But remember, the definition of mobile property can be far broader than the definition of goods, right? But goods are not actionable claims. Now, what are actionable claims is very, very critical and important for all of us to understand, right? And I think we should take some examples of understanding what these actionable claims are. They are definitely not goods, okay? Other than actionable claims and money, right? However, goods include stocks and shares. So shares is definitely mobile property, it is goods, and hence there can be sale of shares that is covered under the Sale of Goods Act. Growing crops, grass and things attached or forming part of land are also considered goods if they are agreed to be severed before the sale. Which means, remember friends, trees are not goods but timber is. So if I make a contract for cutting of trees, it will be considered as sale of goods because it has been agreed to be severed before the sale. Now this is the traditional definition that you find in the Sale of Goods Act, and hence you will notice that we must try and understand this because of several circumstances that have arisen before the court of law in understanding what are goods and where does the Sale of Goods Act actually literally apply. What one must also critically look at is that there is a constitutional definition of goods. This was brought about by an amendment to the Constitution, and if one reads Article 366, subclause 12, you will notice that goods have been defined to mean and include all materials, commodities and articles as well. All materials, commodities and articles as well. Now, why is this Article 366 important? I'll come to that in a little while, but I think it's important for us to understand, saying that the Constitution also defines goods. Why does the Constitution have to define goods? What is the purpose? Why did an amendment bring into place or come into place is something that we'll have to analyze at some point of time as well. Now, friends, the critical component over here that one will have to appreciate is that today we are in an era of the goods and service tax regime, or what we call as the GST regime. Why did the GST regime come into place? If you ask me, I think one of the critical aspects were the difficulty of defining modern elements in goods or defining modern contracts and trying to categorize them as goods. Now you will notice, friends, when sale of goods occurs, constitutionally and even before the Constitution could come, the British government had decided to levy what is known as sales tax. Now, sales tax, please note, is for sale of goods or where sale results in transfer of title. So, unless the contract or the element in the contract amounts to goods and sale, sales tax cannot be levied. And also, if you notice that under the Constitution, levy of sales tax is the domain of the state governments. So, if you look at the federal structure of taxation, today in India, the Constitution says that the state governments can levy sales tax on sale of goods. Whereas the central government quite later on came up with what is known as the service tax regime. So, those kinds of contracts that are categorized as services can be levied with service tax, and that taxation goes to the central government, whereas sales tax goes to the state government. Now, the tiff or the conflict of imposing sales tax has resulted in some very interesting cases before the Supreme Court of India and the various high courts across the country in trying to visualize and analyze the modern aspects of what can be considered as goods and what can happen to be sale. Now let's try and answer some of these, right? I think you should make an attempt to kind of answer the same. Please consider whether the following amounts to goods or not. First and foremost, can we consider human organs as being goods? Can they be considered as material, commodity, or article? Can they be considered as movable property? Now, friends, human organs, you may notice, uh, can be commercial in nature, because at some point of time in India, before we passed in a legislation called the Transplantation of Human Organs Act, we were not very sure about the commercial or commodification of human organs. Today, you will notice that, friends, we say human organs should be gifted or donated, but cannot be bought and sold. We encourage organ donation. We encourage blood donation, because again, whether blood is human organ or not, you will consider that that has been some very serious debate on the same. We talk about donation of eyes, donation of vital organs like kidney and others. But we are saying donation because we don't want commodification of these, though they could be considered as movable property. But you will also notice that medical colleges would want dead bodies for experiment. There is clinical trial that is very crucial and critical to actually advance life-saving drugs. So these are part of the industry of hospital and what we call as the medical organizations. And when they actually trade or when they actually transfer human organs, can we categorize them to be sale of goods? Now, you will again find over here, while human organs can be movable property, we will not want to call them as goods because we consider commodification of human organs against public policy. So you have to understand that though it may fit within the definition of movable property, though we may look at transfer of human organs, say from the deceased family to the medical college, from the deceased family in terms of organ transplantation to someone else, we would not call them sale of goods, right? We are not talking of title that is going to be transferred. We are not talking of commodification, and hence these may not fit within the definition of sale of goods entirely. So one will have to evaluate those kinds of movable property as beyond the ambit of the Sale of Goods Act of 1930. Now you must be wondering, why are we discussing all of these? Friends, we are discussing all of these because, please note, if suppose the deceased family tries to give a human organ, say eyes, but the eyes are not fit for consumption, because the Sale of Goods Act says anything that is a commodity or goods that is to be sold must be fit for human consumption. There must be what we call as merchantability of the goods, right? So if suppose the eyes are defective, because it could be an old man who has died, it could be an old person who has died, he may have already undergone certain kind of surgery to the eyes, and now if you are transplanting the eyes to another person, you cannot certify the merchantability of the same, right? So there are challenges over there. Secondly, you will also notice that the Sale of Goods Act talks about conditions and warranties. Conditions are those kinds of representations or stipulation that are essential to the contract, right? So this is like the description of the goods, and organs cannot be described in any way. You cannot certify that the organ is fit, it is of A quality or B quality. These are challenges, and more importantly, I think the public policy dimension in India is very clear that you do not want to bring in trade and commodification or commerce as applicable to human organs. This is more in terms of the kind of need that humanity has, the kind of requirement medical organizations have, and hence we ought to keep these beyond contracts, commercial law, and beyond the Sale of Goods Act as well. So those are justifications why these would not be categorized as goods. Now let's evaluate whether animals can be considered goods. What do you think? Do you think animals can be considered as goods? Now, friends, again, we will try and evaluate this for many reasons. The reasons are something like this, friends. There was a concept called chattel. It continues to be even a concept today. And you will notice that during early days, slaves were considered sale of goods. Yes, that was there right from Roman times, even to modern times. when slavery was practiced in some of the modern countries, and slaves were actually bought and sold. In many cases, you will notice slaves were even auctioned. They were treated as chattel in one sense, movable property. Now, when it comes to animals, friends, so abolition of slavery happened. The world economy has moved forward. But now we talk about animals. Now, animals, friends, can be bought and sold. For example, you want a rare breed of a dog. Can you buy that dog? Yes, you can. So we say animals again have to be divided into what we call as domesticated animals. It could be a cow, or it could be a buffalo, it could be a bullock, it could be a dog. These are domesticated animals. They are necessary for human endeavors, commercial activity, agricultural purposes, and so on and so forth. Not only that, friends, there are a lot of animals that come within what we call as the consumption market of meat. It could be chicken, it could be any other kind of an animal that is actually taken out for culling. It could be taken out for meat production, and hence this is bought and sold in one sense, right? So these kinds of animals can be considered as sale of goods. You will definitely notice that we definitely accept animals as an integral part of the definition of goods. It can be traded. We have a very famous case where animals were actually sold, but unfortunately those animals had typhoid fever. Now, who should be blamed if the animals had typhoid fever? So what happened in this case was, friends, during the 1860s or 1870s, there was a fair of animals being sold, and pigs were on sale. So it was a fair, it was a trade place for animals, and the seller had surrounded pigs, and he said these pigs are sold in as it were condition. As it were is condition. Okay, so he had put this, and he also said that with all defects. So he disclosed this. Now a buyer comes, he sees the pigs with a naked eye inspection, as we call it, and he bought these pigs, and he took these pigs to his pig farm, and unfortunately the pigs that he bought had typhoid fever, and the new pigs transferred the typhoid fever to the existing pigs, and the entire pigs in the pig farm got infected. Now the buyer got aggrieved, and he went to the court and he said that, look, these were not fit for sale. These were not of mercantile quality, and the seller is responsible for having sold these goods or these animals which are not of mercantile quality. It is a breach of the Sale of Goods Act. Now, at that point of time, friends, you will notice that animals have these kind of risks that we attach. Now, did the seller knowingly sell the pigs that had typhoid fever? If that can be proved, because he said, look, this is with all faults, it is as it is bad condition, and if he did so, please note that could be a serious violation of the Sale of Goods Act. Apart from being a criminal offense, please note the seller would be responsible for violating the Sale of Goods Act, for which the buyer can repudiate the contract. But however, when this case was decided, the courts in England were obsessed with this theory called the theory of caveat emptor. Caveat emptor, which means let the buyer beware. They said, look, this is it's the seller's market, and if it's the seller's market, the buyer should have been careful. Shouldn't the buyer have checked what those faults were? Shouldn't the buyer have checked, as being a pig farmer, doesn't he know whether pigs have typhoid or not? Couldn't he have done some kind of an inspection? So if the buyer was negligent in his own conduct, then he cannot repudiate the contract. He cannot return the pigs back and claim damages. He has to suffer some kind of an injury out of his own negligence or own fault. But today you will notice, friends, as we speak today, the Sale of Goods Act has provisions which we call as the consumer interest provision, or the provisions that go on to protect the buyer's interest. Now, buyer's interest is consumer interest, which means we are probably talking about the exceptions to caveat emptor. We are saying that in some cases, there can be what we call as caveat vendetta, which means should the seller be there? Shouldn't the seller have not offered these animals for sale in the first place, knowing that it had typhoid fever? Shouldn't the seller have checked before making the sale? Look, today, when we say it is the buyer's market, the buyers need protection. You will find several legislations passed by governments across the world trying to protect the buyer's interest, because the buyers unfortunately get exploited. The buyers unfortunately are cheated. The buyers unfortunately face a lot of unfair trade practices from the sellers. And hence, to those extent, you will notice that we have legislations like the Consumer Protection Act, we have legislations like the competition law, which all go on to protect the consumer interest. So today you will notice that the principal rule is caveat vendetta. Let the seller beware. Now you will notice, friends, today in India we have legislations like the Food Safety and Standards Authorities Act. We call it the FSSA Act, under which food, or it could be meat as well, have to have certain standards. If they don't meet those standards, they are not to be kept on sale. Not only that, under these legislations that have been brought about in India, there is a requirement of labeling as well. For example, the simplest labeling requirement could be whether it is a vegetarian or a non-vegetarian food, the green versus the red dot. Labeling requirements could also mean whether they have trans fat, whether they have any kind of nutritious value. These are disclosures to be made. Labeling also means whether it is hazardous in any sense, any good that is to be sold. So there are different labels that have to be informed. For example, one of the labeling requirement is whether it is environmentally friendly. So there is something called the earthen pot kind of eco mark that can be used by products. So these are different kinds of labels that are being introduced by the governments so that the consumers have the right to information about what these goods are. For example, today we are talking of even organic and non-organic goods. We are talking of trying to give consumers the choice, consumers the information, and it is the seller's duty to do that. And if the seller fails in disclosing the kind of quality of goods that he's selling, then the seller would have violated all of these legislations, as the case may be. So I think when it comes to animals and meat, as the case may be, I think the sellers have to beware and they have to disclose the faults in the goods. So the goods have to be of merchantable quality, tradable quality, and unless they are not fit for consumption, they cannot put it up on sale. Right? So animals can be considered as goods. There is no problem. Domesticated animals can be traded. Meat is definitely part of the consumption of sale of goods. However, at this point of time, it is critical for us to understand that we have legislations like the Wildlife Protection Act. Now, under the Wildlife Protection Act, if you see the schedule, the Wildlife Protection Act was passed in 1972 after we agreed to an international convention called the CITES Convention. I think the details are not required right now, but you will notice that trade in certain kinds of animals are now prohibited. We started off prohibiting trade in tuskers or trade in ivory, and you will notice that these animals were actually smuggled, they were killed illegally, they were poached because the ivory was in lot of demand. So today ivory has been a banned commodity. You cannot trade, you cannot transfer. So you will notice there is restriction over there, and you will also see that certain kinds of animals cannot be the subject matter of sale. Right? These are wild scheduled animals, the animals that need protection. They are near extinction, they are endangered, they are threatened kind of species on planet Earth, and hence we do not trade. And any private person holding them is also something that is prohibited. These animals can be part of a zoo, and in India the concept of a private zoo has definitely taken traction. But please note, buying and selling is definitely not something that is permitted. So we can always safely conclude that these are protected animals. They are not part of the sale of goods process, and they are protected under law, for which I think the Sale of Goods Act does not apply. Commercialization of the same is definitely not permitted.